Timeline for a dissolution of marriage. Step 1. Filing for dissolution of marriage. One party files for dissolution of marriage, commonly referred to as filing for divorce. The person filing for divorce is referred to as the petitioner. The petition is served on the respondent. The respondent has 30 days from the date of personal service to file a response with the court. If no response is filed, the next step is to request a default against the respondent. If the respondent does not file a response within 30 days of personal service, a default and default judgment can be filed based on what was requested in the petition. When a default is filed, the respondent can no longer respond to the dissolution without filing a motion to set aside the default, or the parties stipulate to allow the respondent to file a response. If a response is filed, then the next step is for the case to move forward. Both parties are now on a level playing field, and they can begin negotiating for a settlement. Actions in a dissolution matter often include exchanging discovery and requesting temporary orders from the court for child custody, visitation, child and spousal support, property, and attorney fees. During the case, either party can request temporary orders, and the process of discovery can begin. Each party can request pendente lite orders. Pendente lite orders are temporary orders that keep the issues protected pending the completion of the case. These orders are often for child custody and visitation issues, child and spousal support, property, attorney fees, and domestic violence prevention. The process of discovery can also begin. Discovery is simply the exchanging and obtaining of information. Discovery is the time when information regarding disputed issues is obtained. The information can be obtained by documents exchanged between the parties, or it can be in testimony obtained through depositions. The length of discovery will depend on the amount of property acquired during the marriage, assets and debts, the number of contested items, not agreed upon by the parties, and the willingness of the parties to provide information. When discovery is complete, the next step is to request a mandatory settlement conference. When discovery is completed, and if no settlement has been reached, either party may file a request with the court to schedule a mandatory settlement conference. Some courts schedule these conferences automatically. The purpose of this conference is to allow the parties, and their attorneys, to discuss the case and try to resolve contested issues through settlement. The conferences are at the courthouse, allowing either side to request court assistance in resolving a matter. The court does not usually make orders during these conferences. However, the court does offer helpful advice to assist the parties in settling their matter. It is common for the court to order more than one mandatory settlement conference. At any time during the case, any issue can be bifurcated, or separated, from the rest of the case. Some issues may need to be bifurcated or separated from the overall matter. A common issue that is bifurcated in a dissolution matter is the status of the marriage. By bifurcating the issue of marital status, the parties can terminate their marital status and become divorced from each other while the other issues of custody, support, property, and attorney fees are being resolved. If settlement negotiations aren't successful, all remaining issues will go to trial. The court will make orders on all issues that are not resolved by a settlement at a trial. The trial will address all remaining issues in the matter. A trial can be as short as one afternoon or as long as many days or weeks, depending on the number and complexity of the issues. The outcome of a trial is a judgment. A judgment can be reached by settlement. If the parties do not settle, a trial will be held, and the outcome of a trial is a final judgment. If you need assistance with a dissolution matter, please contact our firm to schedule a consultation with one of our attorneys dedicated exclusively to the practice of family law. Contact the Cullen Family Law Group at www.cullenfamilylawgroup.com or 9517154632 for more assistance in your family law case.